Welcome, welcome. Are we ready to get started? Do I have the go ahead? Looks like people are joining. I see those numbers going up, so I'm going to give it like 30 seconds before we get going. Welcome to everyone. Thanks for being here. I see people are still rolling in. Thank you. We're so excited to have you. All right, I'm going to get started. Thank you for joining us for this briefing on the recent Ninth Circuit ruling on our case Doe v. Twitter. So the Ninth Circuit was asked to determine whether our heroic clients could have their day in court against the social media giant who knowingly profited from distributing their exploitation material, or if the lower court was right in dismissing their case under Section 230 immunity. So we're so excited to discuss our victory on this appeal and also dig into the ongoing issues that this decision highlighted. Our panel today consists of Lisa Haba, myself, and Ben Bull. Lisa Haba is a managing partner with the Haba Law Firm, and she's one of my heroes. She's one of the nation's leaders representing victims of sex trafficking and civil litigation. A former sex crimes prosecutor and now a passionate civil litigator, Lisa has taken on international sex trafficking traffickers like Peter Nygaard, as well as major hotel chains for facilitating and benefiting from sex trafficking. And she has a winning record, I will say. And it is my honor that she is on our team representing our incredible clients to hold Twitter accountable. My name is Dani Pinter, and I'm Chief Counsel for the National Center on Sexual Exploitation, NCOSE, and Director of the NCOSE Law Center. I will dig into the case decision following Lisa, but last but not least is Benjamin Bull, our General Counsel for the National Center on Sexual Exploitation and the founder of the NCOSE Law Center. Ben founded and built from the ground up the litigation department at Alliance Defending Freedom, a pioneer in the religious liberty movement. In that effort, Ben created a machine that had more cases at the Supreme Court than any other law firm in the country. He was responsible for overseeing the team that established religious freedom law as it is today. We are honored to have Ben as the architect of our law center, and I'm excited to get his perspective on the Doe v. Twitter decision. Before I turn to Lisa, I just want to kick us off by saying that we are at the dawn of the new internet. The late 90s and early 2000s, the internet was just beginning, and there were legal battles that were waged then that we're living with now. Much good has come from the internet, but also devastating harm. Now is the time to wage these legal battles again on the battleground of the mature and billion-dollar giant that is the online tech industry today. Today, we carry the web in our pockets, and laws like Section 230 no longer make sense. And instead of creating a lawless internet for corporate bad actors like Twitter, we see the success of age verification at the Supreme Court with the Paxson decision as a sign that it's time to reshape the legal landscape. With that, I will turn to Lisa to tell us about the amazing victory that we had at the Ninth Circuit with Doe v. Twitter. Lisa.
Great. Thank you so much for having me. It is an honor to be here with such a prestigious panel. I'm going to take some time right now to walk through a portion of what happened in the Twitter case, which is going to be the portion in which we won. So I get the very exciting portion of this. But what I wanted to talk about here is that we had a number of counts that were dismissed because of Section 230, and two counts that survived the Section 230 block that seems to be plaguing many of these cases. So I'm going to start off by talking about our wins. And I'm going to assume for the purposes of this talk that everyone on here understands what Section 230 is and what it does. So moving forward into the first one, when we brought forth our case, we alleged products liability. And we brought forth three individual claims under products liability. The three theories were basically that Twitter lacks a mechanism to report child pornography easily. Secondly, that Twitter does not allow child pornography that's been reported to be blocked easily. Essentially, just like our clients, it was reported, and while that investigative period was happening, Twitter just allowed views and transactions to keep on happening. Hundreds of thousands of views of that illegal imagery occurred while they were quote unquote investigating. And then the third mechanism is that the search features and search suggestion features and hashtags that are included on Twitter amplify the reach of child pornography across the internet and across the Twitter platform. And one of the points that we had made in that was that Twitter's actual algorithm allows for such hashtags and search features to exist that solely exist for the purpose of spreading child pornography across the platform and helping Twitter profit from the same. Now, the court had to did an analysis. And what was so key about this particular analysis is that we've had a lot of case law over the years that have slowly been developing Section 230. We've seen the guardrails change and shift and become more pronounced as every single one of these cases has come to this point. And what happened in this case is our court further clarified what one of the previous cases illustrated, which was Calise. Calise started talking about what really does a website, what is the requirement for Section 230 to apply? And the Calise case from the Ninth Circuit, prior to this one, talked about this is not the situation where if it happens to involve monitoring, therefore it's immune. If it happens to include third-party content, it's immune. No, that's not the test. The test is, what does the duty that the cause of action is requiring that platform to do require the platform? What is that duty? And so our court in Twitter, in this particular case, really expanded the reach and understanding of that duty test that is implicit across these cases. Now, our court looked at the three different forms of products liability that we brought forth, and we did not win in all three. Two of them, the court felt, did not meet the duty test and would require monitoring of the platform. And I'll quickly mention those two. The not blocking child pornography while it's being investigated, they felt required monitoring. To monitor it, even though our position, of course, was different than that. Our position was that it's already been reported, so you're not monitoring, you're just reacting to what has already happened. But they felt that the obligation to remove it in that capacity would constitute monitoring and publication activity, and therefore Section 230 was invoked. They also determined that when it comes to the hashtags and the search features, that those are called neutral tools. Now, candidly, neutral tools is a judiciary created concept. It's not in the statute. It's not anywhere in the text of Section 230, but there has been case law in the Ninth Circuit that has created this concept of neutral tools. And as a result of neutral tools, they have said that we're not going to punish or hold liable a website for use of neutral tools. So arguably, we had argued that these are not neutral tools. These are tools being used solely for the purpose of disseminating child pornography. That, of course, is not neutral, was our argument, and many other things of that nature. But the court felt again that this was monitoring activity. So understanding the loss on those two, let's talk about the win on the lack of the mechanism to report child pornography. The court took some time and really went through what Twitter requires of somebody when they observe child pornography on the Twitter platform, they stumble across it. A user can review content on Twitter easily. They can view content on Twitter without having an account, so to speak. You can get to it directly through Google if you so choose. But to report child pornography, you actually have to have a Twitter account. So that's one of the first hurdles that the court pointed out. The court pointed out the hurdle that you have to not only be logged in, but you can't do it the way that many other things that you can report to Twitter, you can do through the messaging application within the platform, but not the reporting child pornography. That requires a specialty form. And you have to supply an email address. There's no anonymous reporting. They make the reporting of child pornography on the platform more difficult and more onerous than other types of reporting of other conduct. So the court felt that if plaintiff has alleged that there is a duty to have an infrastructure that allows for the monitoring, removal, and dissemination of pornography, that they have an infrastructure not necessarily about the monitoring, but more about the reporting for a user to be able to report it if the user stumbles across it. That completely falls outside of monitoring third-party content. And therefore, similar to the decision from the Ninth Circuit in Lemon v. Snap, this is going to be a continuation of that same decision, where this is content and conduct by the platform, the infrastructure they created, which has the deficiency. And our complaint, the plaintiff's complaint that alleged that infrastructure deficiency is outside of Section 230. So we are able to proceed on that particular keynote that the infrastructure was deficient. That being the case, that allows us to simply get to discovery. Remember, our win in this case allows us to at least have the doors open to the courthouse so our clients can have an opportunity to try to prove their case. So now we finally have the doors open on their deficient infrastructure. The other key win we had in this case, and we're very excited about this one, is a claim of negligence per se. Now, negligence per se is essentially negligent. You're so negligent that you literally violated the law. There is a law in the United States in the federal statutes that requires that when you have a website comes across material that it would be considered to be child pornography, or they have a reasonable likelihood to believe it could be child pornography, they have a duty to immediately report that to NCMEC. That's right there in federal statute. So when Twitter was made aware of child pornography by the plaintiffs directly, they acknowledged knowing and receiving that tip about child pornography. They acknowledged reviewing the imagery, and they acknowledged that they not only knew exactly what this was, but they were not going to remove it. They also didn't follow up with NCMEC. They did not go to the National Center of Missing Exploited Children and report the illegal images, as was required by federal law. So our claim was that they were negligent per se because they violated a federal statute, and the duty being reporting to NCMEC. So what's interesting about this is the first place this really appeared in federal case law was there's a case out of the Northern District of California that's an MDL, multi-district litigation that deals with social media addiction. It's not even about child pornography. It's about social media addiction and the many, many cases that are involved in that particular MDL. In that, there was a claim raised for negligence per se, based on the lack of reporting to NCMEC. And although the court did allow that to proceed to discovery and overcame the Section 230 arguments from the defense, it really wasn't analyzed. It wasn't explained in a lot of detail about what the analysis behind that was. So our court, the Ninth Circuit opinion that we have here, did actually take a look at that and did explain the rationale and the legal basis behind their correct finding that negligence per se would be an appropriate claim to be able to go into discovery. So the court basically said that the plaintiff's claim, doing the duty analysis again, under what Khalees has started and our court has expanded upon, that duty analysis, looking at it, this claim for negligence per se does not claim that Twitter has to scour its content and monitor it. The court said that they don't have to look at the content and determine if it's triggering for NCMEC reporting authority. And the duty does not even claim that Twitter has to review reported child pornography. Rather, the only claim we made was that if Twitter had already received actual knowledge of such content, that it was child pornography, that they had reviewed the content as they so admitted and we alleged in our complaint, that then they had a duty to promptly report it to NCMEC. So if you think about it, this is not about those cases where they're not really sure. They don't have to go look through their platform. Twitter doesn't have to make sure they don't have child pornography. But if it's brought to them and they review it and they have actual knowledge, they now have a duty under federal statute to go directly to NCMEC and immediately report it. And our allegation that they failed in that duty was upheld by the court. And the court said that this absolutely qualifies as a claim that should be able to progress to discovery, and the courthouse doors are once again open. So in short, the Ninth Circuit has been developing this case law for some time. We felt this was a huge victory, allowing what we know is happening across many platforms when negligence per se is happening in plain sight. And now plaintiffs have an opportunity to finally bring these claims to light and finally seek a remedy through the courts by going into discovery and being able to prove their case.
Thank you so much, Lisa. It's so exciting that this is a path. This is a path, right? Before, where 230 was completely in the way. Now we have a path. So I'm going to turn to the not so fun part. I want to talk about one of the aspects of the decision that I found quite troubling. So, although the court found that Section 230 did not apply to some of those claims, as Lisa described, in a quite, I'll say, confusing analysis, the court found that Section 230 did apply and did immunize Twitter for its alleged role in the sex trafficking of John Doe's 1 and 2. I found the court's decision quite disturbing for several reasons, but at a high level, this is the third decision now. This is the third decision where the Ninth Circuit has rejected a FOSTA claim. So recall that when the public was outraged by Backpage.com, there was a documentary, there was public outcry literally about Backpage.com openly facilitating sex trafficking. Congress actually moved to amend Section 230 with FOSTA SESTA, specifically to allow victims of sex trafficking to bring claims against websites. Yet, each time now that the Ninth Circuit has reviewed a sex trafficking victim's claim under FOSTA, they have rejected it. And so this is the third one. And what we're seeing here is that the Ninth Circuit is literally building a wall brick by brick with these cases to shut out victims of sex trafficking once again under Section 230 immunity. So those cases are Doe's 1 through 6 v. Reddit, which was decided in 2022. Doe v. Grindr, which was decided earlier this year, and now our Doe v. Twitter. So let's dig into a particular aspect of the case that I think is really shocking and I think is really problematic. So, it's part of, and you'll see like the only support for the decision by the Ninth Circuit in its holding is Grindr and Reddit. So you see that like they're coming up with something that I think has no basis in the rest of sex trafficking precedent. They're kind of creating their own branch of sex trafficking law against websites and then just relying on themselves, right? And so that's when precedent, that's why precedent is so important and why we need to tackle this, I think. So let's turn to what the court's reasoning was when it came to our case. So the court acknowledged, as Lisa said, the court acknowledged that Twitter had actual knowledge. They're not rejecting that. They're not questioning that. They fully acknowledge that in our case, as alleged, Twitter had actual knowledge of possession of child exploitation material, child sexual abuse material, child pornography, right? This is contraband. They were in possession of contraband knowingly, which is a crime under federal law. Okay, so the court is acknowledging that. But this is what the court has to say to our trafficking claims under FOSTA. Quote, Twitter's failure to respond to demands to remove the videos, Twitter's failure to respond to demands to remove the videos is not the type of affirmative conduct that constitutes assistance, support, or facilitation of sex trafficking, for which 1591, that's a trafficking statute, attaches criminal and correspondingly civil liability. That is, Twitter did not actually engage in some aspects of the sex trafficking as a legal matter. There's no citation for that. By failing to remove known child pornography from its platform, and then they cite to Grindr. The court goes on to say, while we understand the logic of plaintiff's argument that continuing to make available known child pornography is tantamount to facilitating sex trafficking, that reasoning fails under our prior holding that merely turning a blind eye to illegal revenue-generating content does not establish criminal liability. So there's a lot packed into that holding. Off the bat, I want to say, I think it is a crime. I think it's probably likely that Twitter as a website could be prosecuted just for what happened to our client. So I find that shocking just at a high level for that reason. But another thing that I found disturbing is that so Twitter's only support for this holding that it's not assistance and facilitation is its own decisions, which don't dig into sex trafficking precedent, right? There's an entire body of case law that has interpreted the Trafficking Victims Protection Act, the criminal laws and civil laws governing sex trafficking in this country, in all kinds of other contexts, right? That's been going on since 2008. And there's a whole body of case law. And the Reddit decision only skimmed the surface and actually departed from the precedent that governs the rest of the country's laws regarding sex trafficking. And then this decision didn't touch on a single sex trafficking case and only relied on Reddit. So, digging into that sentence, Twitter's failure to respond to demands to remove the videos, CSAM, is not the type of affirmative conduct that constitutes assistance, support, or facilitation. That I find really troubling because had the court, what you would normally expect to see is the court then demonstrating how in other sex trafficking contexts, what did the courts find amounts to assistance, amounts to facilitation, and then explaining to us why this activity by Twitter isn't the same as that activity or is. But they don't do that. They just conclusively hold that refusing to remove child pornography is not assistance and not facilitation under the statute. I think that's fundamentally very, very wrong. And I think if we think about the words assistance or facilitation, the sex trafficking statute, by design, criminalizes the act of sex trafficking, of course, and provides civil remedies for that, but quite intentionally creates criminal liability and civil liability for people or companies, third parties, who facilitate, right? So those words facilitation and assistance exist in the statute because Congress criminalized the facilitation of someone else's sex trafficking. So it holds accountable somebody not for sex trafficking, for facilitating sex trafficking that is happening by somebody else. Now, if you think about a website, how could a website facilitate sex trafficking? Right? I mean, it's a website. They're not going to be physically interacting with sex trafficking victims. They're going to be facilitating sex traffickers through their website. How else can a website facilitate or assist a sex trafficker except by allowing them to operate on their platform? And that's exactly what we have here. Actual knowledge that sex traffickers were operating on Twitter's platform and Twitter allowing that to continue. That I find extremely disturbing and just fundamentally legally unsound and incorrect. And again, it's its own Reddit decision which it bases this on, and just makes a sweeping claim that the Ninth Circuit precedent is that merely turning a blind eye is not actionable under FOSTA. And I think that's exactly what the statute was intended to punish. And if there was any doubt, Congress cleared it up with FOSTA, right? You might say, well, maybe websites can never be accountable for sex trafficking. Yet Congress acted to say they can and should via FOSTA SESTA. And by the way, that's exactly the activity that Backpage was accused of doing. There is no allegation, and it never was, that Backpage was physically transporting people, physically sex trafficking people, having in-person interactions with sex traffickers, or even in-person relationships with sex traffickers. The allegations were they knew sex trafficking was proliferating on their website. They encouraged it. They made it easier. They didn't remove it. And they allowed it to continue. Well, that's exactly what we alleged against Twitter. And I think that's what the victims in Reddit and Grindr also allege. So I think this is fundamentally wrong. And so we know there's more to do here. And it's an opportunity, really, because we saw Section 230 precedent, which kind of brings me back to my opening statements. We had the internet beginning in the early 90s and 2000s. Congress reacted literally to protect children. The CDA 230 stands for Communications Decency Act. That law was intentionally, specifically passed to protect children from being exposed to harmful content. And the balance it was striking with technology at the time was that if you're doing the right thing and removing, you shouldn't face liability. And now we see, and Congress was grappling with, and there's some language in there that they wanted to protect this new internet, this infant industry. But now we're at a time where, quite the opposite of infant, the tech industry and the internet is the largest industry in the world, making more money than many economies on earth. So now is the time to readdress what I think the courts have not let go of. There has been 20 years of case precedent where judges, I think there is just the human reality of an ingrained belief that websites cannot be held accountable for bad things that happen on their website. And it's shocking to see that even when Congress moves to act with FOSTA SESTA, that ingrained belief persists. And so we need to keep, and that's exactly why we need to bring this case. That's why I want to thank and honor our clients for having the courage to bring this case because it's not easy. They suffered at every step of the way and they're suffering through this lawsuit. But having the court go through that analysis and say that Twitter is immune for that needs to happen because we need to address that, whether congressionally or through the appeals process or through further litigation to get a different decision, to create different precedent. One way or the other, we've got to tackle this, or we're never going to see change, and our kids are never going to be safe on the internet. So I'm excited to continue forward with this case. And with that, I'll turn it over to Ben.
Thank you, Dani. The viewers at home will have to bear with me. There's a violent thunderstorm here and all my lights are out. So I'm using my flashlight on my phone to see you and to see what's in front of me. So it's a pleasure to be here, pleasure to talk about this. And this really was an historic victory. Just some commentary, provide some context and some color to the important information that you all have heard already. You may read, and the opinion referred to this, that Twitter has a zero tolerance policy for child pornography. That's not worth the paper it's written on. It is at best a public relations ploy, and at worst something far, far more pernicious. X on any given day has tens of thousands of child porn images bought, sold, and traded and allowed on that platform, and they know it. Twitter or X could eliminate child pornography on its platform easily by various kinds of AI, face recognition or age recognition software. They choose not to employ that. Some platforms do. Twitter does not. Twitter or X receives significant advertising revenue from child pornography. We put that in the complaint, and the court reported that as part of the opinion. So go take a look at the opinion. You'll see allegations to that effect. Now, the so-called Section 230 was originally called and is still called the Communications Decency Act. There's not a more ironic statement on the planet, perhaps, except for zero tolerance policy for Twitter. Communications Decency Act, Section 230, was designed to prevent child pornography and child exploitation on the internet. It was designed to eradicate child porn on the internet. It's because of the interpretation of the federal courts, it's had exactly the opposite effect. It's basically created an internet superhighway for child pornography. In CDA 230, if you want to draw sort of a word picture in your mind, CDA 230 is like the on-ramp to the child porn superhighway of the internet, except instead of blinking yellow or red, it's a great big green light for any predator or child pornographer to buy, sell, and trade child pornography on Twitter. It's the on-ramp to the child pornography superhighway, and that is Twitter today. For the first time in history, kudos to my colleagues, and kudos to Peter Gentala, one of our colleagues who argued this case in the Ninth Circuit. This is the first time in history a products liability kind of claim alleging negligence against an online platform has been allowed to go forward. That's a huge deal. For the first time in history, a negligence per se claim has been allowed to go forward at the Ninth Circuit. You might say, well, these lawyers just got lucky. They were in the right place at the right time. Again, kudos to Lisa Haba, Dani, Pinter, and Peter Gentala and the entire NCOSE legal team, because this outcome, this case, is a result of thousands of hours of strategy, tactics, hard work, fighting against lawyers, on the other side who are making $3,000 an hour and more. And I hate to give you a little secret, but our lawyers don't make quite that much money. Twitter has more money than, as Dani said, most of the economies of nations on the entire planet. Twitter has that kind of money. So imagine the kinds of lawyers they can hire and do hire. That's the Goliath that we're up against. And, you can overplay the cliche David versus Goliath, but this is modern day David versus Goliath. And Goliath is not dead, but we crowned him pretty hard with a rock right in the forehead. And, time will tell what happens next. Another little bit of important trivia. Tomorrow is day 14 after the decision has been reported. And we should know whether or not Twitter is going to seek what's called en banc review. In other words, they have a right under the federal rules of appellate procedure to ask the entire Ninth Circuit to review and reverse the Court of Appeals decision. We don't know whether they're going to take advantage of that avenue or not. We don't know what they're going to do because they haven't told us. But we'll know within the next 24 hours or so what the next step is going to be. They may file a petition for cert seeking review at the United States Supreme Court. We might file a petition for cert on the issues that we lost in the case. We're discussing all of that. All that is yet to be determined. Now, so kudos to our little team taking on David versus Goliath. Another little bit of background, and this is a result of research that we've done and reliable information that we have that, related to Twitter's zero tolerance policy. When they receive complaints about child porn on its platform, they do act, they do take some action, as they did here. Here, of course, they reviewed the explicit material involving these two 13-year-old children. They reviewed it and said, we've looked at the material and we find that it doesn't violate our policy and we will not be taking it down. And the little boy and his mom said, what? Did you even look at it? How can you say that? We're 15 years old now. We were only 13 years old then. How can you not be taking it down? And it was only because of a friend of the family through the Homeland Security, in other words, law enforcement, reached out to Twitter and told them, this is child pornography, you have to take it down, that it was taken down. But in the meantime, after they knew it was child pornography, and before they took it down, there were several 100,000 views of the images. There were 200,000 downloads of the images. All of this was avoidable if Twitter had just either not allowed it or taken it down. Now, the tragedy that is going to be ongoing for these little boys and countless other children who are sexually exploited by images on Twitter is that these 200 downloads, they can be uploaded to the internet at any time. What goes up on the internet, for the most part, stays on the internet. And these children, as grown men, will know that somewhere, someplace, images of them have been uploaded to the internet because of the misconduct and bad behavior and avoidable behavior of Twitter or X. So there are real victims in this case. And while we're thrilled at the victory that we have and planning strategically to undo some of the setbacks we faced in this case, perhaps at the Supreme Court, perhaps en banc, there are real victims in this case. And not just the two little boys who were victimized by Twitter, who made money from these images, and they haven't given the money back. They make money advertising from tweets. And remember, there are thousands of tweets and thousands of views of these children, resulting in net profit for Twitter. They haven't offered the money back to the kids. They haven't offered the kids anything to recompense them for the injury they suffered. But this case involves real children, two little 13-year-old boys, and countless thousands of other children whose images are being exploited right now, today, on Twitter. Now, there's a lot more we could talk about this case. We're going to try to, part of the case has been remanded. The part of the case that we won may well be remanded back to the trial court, and there'll be another first if and when that happens. For the first time, we'll be able to conduct discovery against Twitter. We'll be able to find out who makes these decisions on CSAM. Why haven't they employed existing technology to expunge or eradicate CSAM or child pornography from their platforms? This wasn't an accidental decision. They read this decision as well as we do. And the opinion says that there are other forms of protection, higher levels of protection to stop child pornography on the internet that they've chosen not to adopt, and that was an allegation that we made. Again, so this case is taken as a result of years of hard work, countless hours of hard work. Kudos to Lisa Haba and Dani Pinter, Peter Gintala, Kristen Price, and the entire legal team. So we're so proud of them. The case has a long way to go. The Ninth Circuit is an important court, as Dani and Lisa have pointed out. It's one step below the United States Supreme Court. And we know that at least two justices on the Supreme Court, one in particular, Justice Thomas, has been very outspoken about it, believe that the lower courts have misinterpreted CDA 230, that the name Communications Decency Act, Section 230, means what it says. It was intended to block or stop this kind of sexual exploitation on the internet, yet it's been interpreted exactly the opposite way, as if we're living in an Alice in Wonderland and we've gone down the rabbit hole. Eventually, I think it's going to take the U.S. Supreme Court to undo this mess created by the lower courts, although we're going to enjoy the victory that we have, the historic victories, allowing two tort claims to go ahead against Twitter on behalf of these children who've been so badly treated by Twitter and injured. So, Dani, back to
Thank
you.
you. Yeah, so I think we're just going to have a quick panel discussion. We've got a little less than 10 minutes. I've got a couple questions for you guys, and maybe we could do one or two questions for the audience. If anyone wants to put in the chat, I can take a look at those. The first question I have is for you, Lisa. You know, FOSTA SESTA it was passed in 2018. We only really have a couple of these decisions coming out of the Ninth Circuit. I think just one at the 11th Circuit. Do you think that another court could go another way? Could we see a split? Or do you think there's going to be maybe a chill from these bad decisions? What are your thoughts? Oh, we can't hear you, Lisa. Sorry.
Sorry about that.
Yeah.
It's hard to predict where it's going to go because it's going to take a plaintiff's lawyer to plead this and be able to get into another jurisdiction. One of the problems we run into is most tech companies are located in the Ninth. And even when we filed cases in other jurisdictions, having, theories under jurisdiction that potentially could bring us in another outside the Ninth, they will move to transfer to the Ninth because the case law has been developed there in a way that seems to put tech in the best light possible. The only other jurisdiction that has even addressed the FOSTA issue is the 11th at an appellate level. So it's going to be very hard to get into another jurisdiction because of where defendants are all located. That being said, if we can get into another jurisdiction and they were to look at FOSTA, the intent behind FOSTA, the text of FOSTA, yes, I do think it's possible that we could get into a different opinion and maybe create a circuit split. And here's one of the key problems with the Reddit analysis. So Dani talked about this a minute ago, but just to kind of recap, the Reddit decision was a case involving the Reddit platform where there was 6 Jane Does. It was intended to be a class action, but it was really going to be a situation where they were alleging that child pornography was rampant on Reddit, that Reddit was aware of it. Even when they removed it, it popped back up again. They were notified about it. Sometimes they didn't remove it, but there was a lot of prolific child pornography being disseminated on Reddit. And the court said CDA 230 blocks it. They applied the Reddit decision applied FOSTA in a very bizarre way. They looked at the text of the TVPRA, the Trafficking Victim Protection Act. And even though there's a civil cause of action, which allows a lawsuit to be filed against a direct perpetrator, the actual trafficker who's actually trafficking the person, or an entity that benefited from that trafficking, like a website, for example, or a hotel or some other entity that maybe didn't directly traffic the person, but benefited from their trafficking experience, it allows two paths forward. Now, under the criminal prosecution statute, which is also housed in the same chapter but a different statute, it's the statute number is 1591. Under 1591, the criminal prosecution statute, you can also prosecute for direct perpetrator prosecution, and you can also prosecute for benefiting from a sex trafficking venture. So looking at this, we have a criminal way to go after those that would benefit from it. We have a civil way to go after those that benefit from it. What the Reddit decision did is it collapsed those two things. The Reddit decision said that the only way a website can be held accountable under FOSTA is they have to directly be involved at a criminal level for there to be civil liability. So let's think about that for a second. We have civil liability, which is a lesser standard than criminal liability. And yet, unlike any other business in America, unlike any brick and mortar, websites get special protection. Websites are put in a position where they are given this higher level. And so the Reddit decision was so difficult to overcome that the 11th Circuit has adopted it, and everywhere in the Ninth has adopted it as well.
Yeah, that's so important, Lisa, because I think everyone needs to try and like wrap your heads around that. That everywhere else, if you're a hotel, if you're a taxi, if you're a landlord, you get a standard known as the should have known standard. If you should have known, you can be sued. But if your website, it's criminal standard. Why? Why in a statute, FOSTA, where Congress was moving to provide an avenue for relief for trafficking victims, did they create a different standard under the trafficking statute for websites as to other defendants? I think that was really wrong. And so that's why I hope that another circuit would go a different way. But 230 has this nasty quirk where unlike other areas of the law, like for example, if the Ninth Circuit and the 11th Circuit don't usually care what each other think, to be quite honest. They will come up to their own conclusion under the law. But whenever it comes to 230, the Supreme Court has never interpreted Section 230, not once. All of the 230 precedent we're living under came out of the fourth district. The fourth district in a case called Zarin, I think it was versus AOL, or the fourth district interpreted Section 230, and all of the circuits just followed that. There's just been no departure. It's very odd. And so unfortunately, I'm seeing a little bit of a trend here with FOSTA SESTA. Why doesn't the 11th Circuit just decide for itself? Why is it following a sort of bizarre leap that I think the Ninth Circuit did? I think that was fundamentally wrong, doesn't follow the language of the statute or the intent of Congress. It's very odd. So, Ben, did you have any thoughts of that? For maybe I could ask you a different question.
Yeah, just a couple of thoughts that are coming to mind as you're talking about it, and the outrageous, we talk about circuit splits. We do have a split with the federal district. Remember, the Ninth Circuit held that child pornography on a platform like X is immune from civil liability. Well, the Federal Court of Appeals for the Northern District of Alabama, in a case we're involved in, we have a class action lawsuit against Pornhub. The federal district court there held that child pornography is not immune from civil suit by CDA 230. So we have the Ninth Circuit saying, no, you can't sue X because they've got child porn. And the federal district court in Alabama is saying, yes, we can sue Pornhub because they knowingly possess and disseminate child pornography. So we do have a split, granted not a circuit split, but we have a split between an important federal district court in a class action lawsuit. Our team has litigated as co-counsel, and this lawsuit in California, in San Francisco at the Ninth Circuit. Let me talk for a second about our frustration in connection with law enforcement. There is another reason why child pornography or CSAM is allowed carte blanche and is untouchable on the internet, and that's because of the failure of the Federal Department of Justice to enforce existing law. You've just heard a rundown on the existing law by Lisa and Dani. There's a criminal side to that, which is not neutralized by CDA 230. There's nothing to stop the Federal Department of Justice from indicting X tomorrow, this afternoon, or Pornhub, or X videos, or Reddit, or any of these companies which knowingly, and they admit knowingly, have child pornography on their platforms, have monetized it, and are making money from it. Nothing to stop the Department of Justice from doing that. And for that matter, I believe state attorneys general have enforcement under their state laws, since there are victims in places like Alabama and Florida and California, in every state, there are victims whose images are being monetized and disseminated and possessed by these online platforms. And as we know that under federal law, mere possession of child pornography is a felony. Well, how about possessing hundreds of thousands of child porn images on one platform like X? How much more criminal is that? Yet the Department of Justice in Washington, D.C. won't crawl out of its office to do anything about it. And it's not just uh, one administration. These laws haven't been enacted really since haven't been enforced since they were enacted. Both Democrats and Republicans have simply sat on their hands and not enforced existing laws against child pornography on the internet, against internet platforms. That's my only comment.
Yeah, no, thank you, Ben. And that brings us to time. But I'm glad you raised that because we didn't really dig into it. We have this alternative theory that really the Ninth Circuit didn't engage with this time because they basically said we already dealt with it another time, which I don't think they really engaged with it then. But essentially, that Twitter's own actions of knowing possession of CSAM really has nothing to do with third-party content. Once they're committing their own crimes, it's really irrelevant that the CSAM came from someone else. And I believe in that theory. I think that the Northern District of Alabama got it correct. Judge Kugler, shout out to you. I think he was absolutely correct. And so I do hope to see some further decisions on that vein. But we'll wrap up there. Thank you so much for joining us. This is a really exciting case. Thank you to Lisa. Thank you to Ben. And most importantly, thank you to our clients and all of you. Please support our work if you can. Go to our website at endsexualexploitation.org. And thank you for joining this webinar.